Good evening, everyone, and welcome to the National Press Club. My name is John Donnelly, and I'm a reporter at Congressional Quarterly. I cover defense. I'm on the board here at the National Press Club, and I'm chairman of the Press Freedom Committee here. Before we get started, a couple of housekeeping notes. Now would be a good time to turn off ringers on your smartphones or other noise-making devices. Secondly, this event is being videotaped, and it will be available for viewing on our website at press.org. And if you're interested in joining the National Press Club, if you're not already a member, you can get information about that too on the site. On May 3rd, this Thursday, at 9:30 a.m., in this room, we are co-sponsoring an event with Freedom House to unveil their 2012 ranking of the world's countries according to their records on press freedom. So we hope you can make that. And finally, in the housekeeping department, we're going to try to wrap up here around 7:30 or a little before if we can, because I know many of you might want to watch the President's address this evening. Press freedom and open government are at the heart of the National Press Club's mission. As reporters, we don't lobby, but as an organization, the Press Club has been a strong advocate of a national shield law that would protect reporters from being forced to reveal their anonymous sources except under extraordinary circumstances. And we at the Press Club regularly weigh in the courts, in Congress, and in the media to fight for the right of reporters to do their jobs here and abroad, and for the right of sources to provide information without fear of reprisal. And that's the core of tonight's discussion, the tensions that arise when the government cracks down on leaks, especially leaks of classified information, and reporters get caught in the net. This event would not have been possible without our friends at the Overseas Press Club of America. And this is the first time, as far as we know, that our two groups have collaborated. And I want to thank them for their leadership on this issue. And now, to moderate our panel, I give you David Andelman, President of the Overseas Press Club of America, and also a member of the National Press Club. David?
Thank you. Great pleasure to be here. I am David Andelman. I'm the editor of World Policy Journal, magazine published in New York for global audience, and president of the Overseas Press Club. I'm delighted to be here. This is our first joint event. What better subject? The Obama administration's crusade against leaks of government secrets and against some of the journalists who report them. When I took over 2 years ago, one of my priorities was to begin sharing events between these two polar institutions that so define American journalism, national and foreign correspondence. As it happens, I happen to be the good fortune of a practitioner of both and a member of both institutions. But none of this would have been possible without the Herculean efforts of one of my predecessors as OPC president, and for years the leader of our Freedom of the Press Initiative committee, Larry Martz, who has embraced the subject we're discussing tonight and conceived of this evening from the get-go, and of course my counterpart at the National Press Club, Teresa Werner, and John Donnelly, who you've just seen. I'm going to let our panelists describe. I'm going to let our panelists describe in far more vivid detail than I could the ordeal and their responses that led to our being here, especially James Risen of the Times, New York Times, where I spent 12 wonderful years, and I'm sure we both regret it today, but maybe not a little. He's repeatedly been subpoenaed to testify against an accused leaker. And to my immediately left, James Bamford, author of The Puzzle Palace, really the encyclopedia for anyone who wants to peek behind the curtain or under the skirts of the National Security Council. I'm sorry, the National Security Agency and the Council, too. And Matt Miller, who served as the Justice Department's Public Affairs Director for the administration's first 2 years. I'm serving as moderator. Jake Tapper of ABC was supposed to be here in this spot. He, of course, suddenly discovered that the president has attempted to upstage us in some fashion and has gone off to Afghanistan, so he's monitoring and holding down the fort at the White House press office. So I'm fitting in for him. He would have been the perfect foil, having personally challenged the administration's policy on leaks at a White House press briefing in February, on the record and on camera. But as you all know, he's not here. So let's start with James Risen. Sorry, there are two Jameses here, aren't there? Go back to the beginning with us, if you can, and tell us the story about how it all began. And I know that there are certain constraints, I believe, you have, because this is still wending its way through the judicial system.
Yeah, I mean, first of all, I appreciate your having me, and I think it's great that the Overseas Press Club and the National Press Club have gotten together. My case is still pending, so there's a lot of things that I can't discuss. The Justice Department has appealed the case to the Fourth Circuit Court of Appeals, and the oral arguments in that appeal are going to be held on May 18th in Richmond, Virginia. And so my lawyers would kill me if I said too much. But I can talk a little bit about how the case started and where, the public side of it. I wrote a book that came out in 2006 called State of War, The Secret History of the CIA and the Bush Administration. And about 2 weeks prior to that, I wrote a story for the New York Times about how the Bush administration was conducting warrantless wiretapping through the National Security Agency. And that was both in the Times and in my book. And the Bush administration began a leak investigation immediately after our story, a story in the New York Times came out about the NSA wiretapping. And they convened a grand jury in Alexandria, Virginia, federal grand jury, and then they got a lot of FBI agents working to try to find out who had talked to us about the NSA story. And then at some point later, they decided to also investigate other things that I had written about in my book. In fact, they seem to have, I think I sold a lot of books at the FBI and the Justice Department because they seem to investigate all kinds of things in almost every chapter I wrote. I would hear either firsthand or secondhand about their interest in various aspects of my book that I found kind of flattering. And eventually they decided to, they decided not to subpoena me or try to find through me or my co-author for the New York Times, Eric Lischblau. They decided not to subpoena us on the NSA story, which I believe they did because they knew politically that would be difficult for the government to have a knockdown, drag-out fight with the New York Times on the NSA story. And so they began to look for other things in my book to come after me on, and I think it's fair to say that they were kind of scouring my book for things that had upset the CIA or the FBI or the White House. And they settled on one chapter that I wrote about Iran and the CIA. And so in 2008, I was subpoenaed about trying to find my sources on that chapter. And they had kind of a shotgun approach the first times the prosecutors talked to my lawyers. They had a very wide lens of what they were interested in. And finally, they kind of narrowed it down a little bit, although not very much. Anyway, I was subpoenaed, I think, in 2008. Then I got that subpoena eventually ran out and expired, and then I was subpoenaed again by the Obama administration. I can't remember when it was, probably 2010. And then I got subpoenaed, and then that subpoena got quashed by the judge, and then there was another subpoena in there somewhere. And then there was another, there was like 3 or 4 subpoenas. I kind of lost track. Eventually the judge the district judge more or less sided with me on most issues, and late last year, sometime the government also lost a bunch of other, several other issues in the case, and so their case was not looking too good, so they decided to appeal on several issues, including whether or not I should be forced to testify. And I think the most important thing for right now that I think people should be aware of is that the latest filings from the Obama administration is in this appeals court. They want the case to be very on the fundamental issues. They've said in there that there is no reporter's privilege. And they want the judge, I think they want the court to rule on a fundamental constitutional issue of whether or not there is a reporter's privilege in a criminal case, which makes this case, you know, kind of have a broader import than might otherwise have. And so that's why I think it's become a pretty important case. It's a fairly basic constitutional issue for the press, whether or not there is a reporter's privilege. And I think it's something that a lot of people outside the press don't really understand, they don't really care about. But I think the basic issue is whether or not you can have a democracy without aggressive investigative reporting. And I don't believe you can. So that's why I'm fighting it.
I want James to, the other James, James Bamford, to weigh in next. I want to point out that we do have a fairly illustrious audience here, including one of the principals in this case, Tom Drake, who's sitting there. I hope he'll have something to tell us about a little bit of his thoughts after we get through with our initial remarks. But James, you want to take it next?
Sure. Thanks, and I do appreciate being here. This is a room I was in about 16 years ago. I got married in this room, so the press club, and particularly this room, has.
And you haven't regretted it.
No. So it has a definite meaning for me. Just to talk a little bit about one of the key issues involved in all this leak investigation is the government assumes that what they're charging somebody with is classified information. But that is not just because somebody takes a top secret stamp and puts it on a piece of paper, doesn't mean it's top secret. The government seems to assume that a lot of times, just because you have a stamp and some clerk puts a stamp on a piece of paper, that doesn't mean that that is top secret. And I'll just give you some examples of why that, how that's affected me and why why I come to that conclusion. When I first wrote The Puzzle Palace a number of years ago, I got in a lot of documents under the Freedom of Information Act. One of those documents was a prosecutive summary I got from the Justice Department about a criminal case that the Justice Department was actually looking into charging the NSA. I mean, it was the first time they were actually looking to charge an actual agency with criminal conduct. And they read the Miranda rights to the people on the executive level at NSA. Well, the Justice Department went over that, released a redacted version of that document to me. So it was unclassified. It was released by the Attorney General. And then NSA had not taken a look at the document, and when they saw the document, they reclassified it as top secret. So they came back to me and they said, you've got to give that document back because it's now top secret, even though when I got it, it was unclassified, and as far as I was concerned, it still was unclassified. So I had to go through a lot of, we had a lawyer, I had to deal with the Justice Department over this issue, and we found this little phrase in the executive order on secrecy that said once a document's been declassified, it can't be reclassified. So we kept sending that back to the Justice Department, and they kept saying, well, despite that, we still say it's top secret and you should give it back. Well, I never gave it back, and they never did. They threatened me with prosecution, but we never gave the document back. But again, here's a document that was unclassified when it was handed to me, and then they considered it top secret. But then if you look at a different law or executive order, it says it's not top secret. So what is top secret and what isn't is in the eye of the beholder sometimes. And then I used a library down in West Virginia, or down in Lexington, Virginia, actually, the George C. Marshall Research Library, and I got a lot of materials there from some former NSA people who left their papers there. William F. Friedman, after he retired from NSA. And the NSA actually went down there, I guess with the FBI or somebody, after my book came out, and raided the library and pulled a lot of this stuff I used in my book off the shelf and ordered the librarian to lock this material up again. And that led to a large suit against NSA by ACLU, American Library Association, a bunch of other groups. And then one of the sources who actually had left material there and who I interviewed was a former director of NSA, Marshall Carter. And the current director of NSA at the time flew out to Colorado where he was living, the former director. They met in a secure location, and they threatened, the current director at the time threatened the former director with prosecution if he didn't pull his papers from that library and never talk to another reporter again, which he agreed to do, and they never prosecuted. To get more recent times, I've been involved with a fair number of legal cases involving classified information. And the most recent one was involved Thomas Drake. He was a senior official at NSA, senior official being, you know, the rank of equivalent of a general or whatever. And the NSA charged him with 5 counts of espionage, felony espionage counts, and several other charges, which would have given him about 35 years in prison. And although it's spoken of quite a bit, he was never really charged with actually leaking the documents. He was actually charged with just having the documents in his house. But I was hired by the defense to show that the information that the government was charging him with, again, they were charging 5 felony counts for leaking top secret information and so forth, that my job was to show that that information isn't secret. It's not even classified. Not only that, the government itself had released the very same information. And that's what, just a little show and tell, that's what, this would have been my testimony in the court case. And this is the documents that I was able to show that came from, they were speeches by NSA directors or whatever, or documents in the Pentagon, whatever. I was able to show that all the information that they're charging him with, leaking, which they were going to put him in jail for 35 years, is found here, not just found in the public domain, but had been released, positively released by the government. So when we presented that to the prosecution and the judge, they came back and they threw the entire case out, the entire case, and they finally settled with Tom Drake on what was basically less than a parking ticket. It was a misdemeanor for abusing his computer that required no jail time and no fine. So this is the same agency, the NSA, and the same Justice Department that were about to put him in jail for 35 years and put his life through hell for 4 years before that, when that information that they were charging him with was sitting right out there in the public domain and released by the Pentagon and NSA. There's all kinds of information that they released. And so Tom Drake is sitting here tonight as opposed to in a jail where had nobody done the homework to look and see whether this was really secret or not. And that's the problem. It's going on and on. They're charging people with releasing information, leaking information, and the government itself, most of the time, doesn't have the slightest idea what is out there and what is classified. They threatened me with prosecution twice. Once was on that first time when I refused to give a document back, and the second time was when my book was released, and they said I had all this classified information in it, and they were threatening me with prosecution until they started going through the back notes and found that everything in the book came from a public source. So that's what I think the public has to understand, and what journalists have to realize is that just because the government says that's secret or that's top secret or whatever, doesn't mean that it's secret or top secret, and you have to fight them wherever you can to show that that information that they're alleging is secret is not. And there's a good number of times, this isn't the first case that I worked on like that, you're able to show that what the government is charging is not secret at all. It's just unclassified. Anyway, I appreciate being here.
James, thank you. Matt, I don't mean to gang up on you, but I would note that...
I knew it was coming.
No, but I would note that we did try to get someone from the current and existing Justice Department, and they refused to send anybody. So you are the stand-in, even though you are not officially with the Justice Department anymore. You did play a role, I believe, at some point, and we'd love to hear your thoughts on this.
So I want to start by picking up on something that the James to my left said, which is that we cannot have a democracy without aggressive reporting. And it's something I would agree with, and I think something that people in the Justice Department, people in the White House today would agree with. What I think happens, unfortunately, is that too many of the people who are critics of the cases that this administration has brought, what they do is they equate indictments of people for leaking classified information with a war on whistleblowers or war on the press. And when you look at, and it's a buzzword that takes off and it sounds good, but when you look at the actual cases that have been filed, it's hard to classify most of these cases as true whistleblowers. Tom Drake, there are 6 cases that have been brought in this administration, 5 by the Justice Department, 1 against Bradley Manning by the Pentagon. And I think in Tom Drake's case, you can make an argument that he was acting as a whistleblower and trying to expose government wrongdoing. I think the Justice Department did have good intentions in bringing the case, but I think Drake can credibly argue that he was a whistleblower. If you look at the other cases, it's very hard to look, and we look at Jeffrey Sterling, who is indicted, and Jim probably will have a hard time talking about this case. This is the one that's pending, where the subpoena is pending. Jeffrey Sterling is charged with leaking information that is reported to be about U.S. attempts to sabotage the Iranian nuclear program. Extremely important effort to national security. John Kirikow is charged with, among other things, leaking the identity of a covert CIA operative. Something the kind of thing that if a covert operative's cover is blown, is extremely damaging to that operative and to anything he might be involved in. And you go down the list, and these other cases are all similar cases where it's very hard to make an argument that these people were whistleblowers. And so if you step back, you have to ask, what is the government supposed to do about this if it sees leaks of classified information? You can look the other way, which they do in most cases. There's a question of both resources and discretion. The government doesn't have the ability to either investigate or prosecute every leak of classified information, or in some cases where the leak is so blatant or it either has caused harm to national security or it has the potential to harm national security, the government has the responsibility to enforce the law. And the law says if you are given classified information, you are forbidden by law to disclose that information to anyone that's not supposed to have access to it. Now, I think there are gray areas. In cases of true whistleblowing, there are things I think whistleblowers ought to do before they go to the press. They can go to inspectors general, they can go to congressional committees with oversight responsibility, and there probably are some cases where they ought to go to the press. And in those cases, I would say you can make an argument the government shouldn't prosecute, and in fact, they don't. The first case that Jim brought up, the warrantless wiretapping case, Tom Tam admitted on the cover of Newsweek that he was the source, or at least one of the sources, for that report. He's never indicted, never prosecuted, and is free today. And I think one of the reasons he's probably free today is because the leader of the current attorney general and the current president both said before they were in office that warrantless wiretapping is illegal. And if it's illegal, that's true whistleblowing, and he shouldn't be prosecuted, and he wasn't.
Before we go to the audience, or before we actually, or ask Tom's thoughts on this, which I'd love to hear, I want to get to beneath the sort of the next layer down, if you will, and that is this whole question of can we keep secrets, and what is the nature of whether, and James mentioned that very rightly, a lot of things we just aren't worth classifying. And I was telling him beforehand, I wrote my next previous book, my second book, with the Alexandre de Marange. And Marange was the longtime head of French intelligence. For 12 years he headed it. And he always used to tell me when we were working on the book, he said, the Americans just can't keep a secret. He said, I'm not going to tell them anything worth knowing because they're not going to keep a secret. So the question is, first of all, do you think the system is in fact broken? And any one of the three of you can answer this, I hope, or Tom for that matter. Is it broken, and are we therefore playing games with a broken system, or is it something that's worth preserving in some fashion?
I'll start. I think we do, without a doubt, overclassify information and classify too many things that have no business being classified, and that makes it that's one of the challenges then in enforcing a no leak policy or enforcing leak laws. And one of the things the government tries to do, I know the department tries to do, is it's why not every leak of classified information is investigated or prosecuted, because some classified information isn't rightly classified. It's also something the administration has tried to address. The president has ordered a number of panels and initiatives to reform the classification of information, but it's one of those problems that you find, I think, is bigger than any one White House. It's something that's existed for years and years and years.
James on the end, I won't keep saying James on the left because I don't know that he necessarily is, but James, what do you think? I mean, you're the one, you're out there every day trying to report on these things. Is the classification system broken?
It's always been broken. I mean, there's nothing new about that. It's a joke. It's always been a joke, and the difference today is that from about the mid-'70s to the time of the Plame case, there was an unspoken agreement between the government and the press about leaks. It was kind of like that scene in Casablanca with Claude Rains. I'm shocked that gambling goes on here. We would get a story, we'd write it, the CIA or the FBI or somebody would get all upset about it, and they would start a leak investigation, and then nothing would happen. It was, inside the government, it was known as kind of a joke. The FBI agents who were assigned to leaks hated it. They didn't want to do it. The internal security people at the CIA knew that they had better things to do. And then what happened, I think, was after 9/11, people started taking this stuff more seriously. And then this guy named Pat Fitzgerald came to Washington and broke down this unspoken agreement in the Plame case. And he said, he looked at the law and said, there is, I can subpoena anybody I want. I'm going to go after reporters. And they started subpoenaing reporters all over Washington. Ever since the Plame case, and he was successful in the courts in upholding a lot of those subpoenas. And so ever since the Plame case, the Justice Department, every new prosecutor thinks they're going to be Pat Fitzgerald. And so they all are eager to get involved in leak investigations, and they're subpoenaing reporters, including me. And I think that the problem is that this unspoken agreement is broken down that we had since the mid-'70s, and nothing has really replaced it. And I have to say, I still don't understand the Obama administration's incentives and motivation in becoming, much more aggressive on leaks than even the Bush administration was. In fact, they're much more aggressive than any other administration in history has been on this. So that's kind of the one mystery on this, is why they have become more hardline and aggressive in going after leaks than anybody else ever has been before.
I'd love to hear before. Okay, go ahead, James.
I just had one comment on I think the Drake case is an obvious example of how the system is broken. And there doesn't seem to be any effort by the Justice Department to try to correct it. They're just going after more alleged leakers. But the problem, I think, is that it's a double standard. They're going after these sort of little guys, little guys that happen to have made a comment here or a comment there, or try to get the story out, true story about something coming out. When, as Matthew just mentioned, the Obama administration agreed that the warrantless wiretapping activity was illegal. Well, why aren't we prosecuting them? How come they aren't being brought up on charges? We have the torture. We're prosecuting somebody who has been a whistleblower on torture, but we aren't prosecuting anybody who did the torture. You had all these telecom companies, and they know what the law is. The law is very simple. The Foreign Intelligence Surveillance Act, that's what their counsels are supposed to read to them. And you could very easily see that you're violating the law by doing this. And what do they get? They get immunity. So everybody that wears a little flag lapel pin and salutes the White House gets immunity, while the little guys who are out there trying to talk about programs that aren't working, programs that are violating Americans' rights, they're the ones who are picked on. So, yeah, is the system broken? It's broken in a million pieces.
I'd love to hear from Tom in one respect, if you would favor us with a thought. And going back to what James on the end was saying, that the atmosphere has changed in the Obama administration. Now, you've been in the NSA for a long time. Did you have a sense that something has changed in the last 3 years, 4 years, say there, than in previous years, in either in the way confidential information, secret and top secret information is handled, how reporters are able to deal with this, and so on? What's been the internal feeling within the NSA?
I'm going to come right to the point, given what I've experienced.
Okay.
I believe that what you have is the increased expansion of a national security state, which is absolutely anathema to the U.S. Constitution. It's bifurcating our form of government, fundamentally. You have two whistleblowers, my friend John Kiriakou here, who has been alleged in a criminal case brought against him, alleged to have disclosed, covert operatives, alleged to have disclosed, the names of which have never been made public, never been revealed publicly. The only place they show up is in a sealed Gitmo filing. Now you tell me, is that a proper use of DOJ resources? You're looking at the two individuals on two of the biggest scandals, with cover-up and secrecy on top of that. Torture, rendition, warrantless wiretapping, which, by the way, is just the tip of the iceberg. The Stellar Wind program, is the much bigger program, right, which turned the United States of America into the equivalent of a foreign nation for dragnet electronic surveillance, I'm the only person indicted from that DOJ investigation was launched after the Rise and Lichtblau article was published in December of 2005. The only person indicted for having exposed and disclosed in significant detail with formal investigations in an unclassified manner with a reporter. Right?
But why do you think this has changed in this administration from the previous one?
Because they want to keep secret what they're doing in secret, and especially when they're breaking the law, when they're in fundamental violation of our tried and true practices and principles. My friend John Kiriakou is the only person that's been indicted with respect to the torture program. Why? Because he talked about it, because he revealed it, publicly, that he was against it, that he refused to engage in the training associated with torture. Torture is illegal, warrantless wiretapping, data mining is illegal. And yet what the government has done is criminalize the exposure and disclosure of what they want to keep secret, and yet there has been no indictment. There's been no prosecution that's led to an indictment of those who actually engage in the illegal and unlawful behavior.
Hey, Matthew, do you want to respond to that?
There's a lot here. But let me start by saying John Kiriakou has not been indicted for disclosing information about torture. he's indicted for disclosing the names of CIA operatives. In fact, it's this administration that released the memos that showed what the last administration did in the government's name in torturing people. It's this attorney general who appointed a special prosecutor to look into torture. Now, that investigation may not yield indictments. Some investigations don't yield indictments, but that's the way investigations work. Prosecutors make the call on the facts and the evidence. You certainly cannot say that this administration has not done a full investigation of torture. To go back to the broader point, though, one of the things, you can say that it didn't. You can say that it didn't give an investigation that produced a preordained outcome. That's certainly true, but it has been. It has been fully investigated by a respected prosecutor, John Durham, who anyone who's worked in the prosecutorial community will tell you would not pull his punches for any reason.
If the government's engaged in illegal activity, they have an incentive to cover it up. There are operatives at CIA who committed torture on a very large scale.
Well,
it is well known for those who were involved.
I can tell you, I worked
NSA fundamentally engaged in broad illegal behavior, and they did it willfully with the approval of the Bush White House.
Okay, I don't want to get into it. I don't want to get into it.
Right. Right.
All right. I'd like to open it to other folks here, and are there other questions for our panel? Way in the back there. Yep. Right.
With respect to the Durham
Please identify yourself. You can
Oh, I'm
stand up
sorry.
and-
I'm Catherine Hawkins of the Constitution Project Task Force on Detainee Treatment staff. With respect to the Durham investigations, am I correct that any declinations of prosecution in this administration or the prior administration about why no indictments were brought are classified?
I don't know. I left before that investigation was, while that investigation was ongoing, so I just don't know the answer to that.
Okay.
Sure, right here.
Andrew Craig from the Justice Integrity Project. First, thank you for having this important forum, and also Matthew Miller for showing up. Two quick questions.
A brave man.
One is, isn't it cowardly for the Obama Justice Department not to send a representative to this very important joint historic program? Secondly, John Durham, who you spoke so highly of, and Nora Danahy, who investigated the political prosecutions that led to the firings, are both tainted by being found by the Second Circuit as withholding evidence in important cases that created sanctions by the Second Circuit. Attorney General Mukasey and Attorney General Holder then named tainted prosecutors to these investigations, including John Durham. Why did Eric Holder name John Durham under those circumstances to this critical investigation?
So I'm not familiar with the Second Circuit case you're referring to, or the.
It's the Spadoni case.
But I can say that John Durham is a respected prosecutor inside the department. He's respected by people he's put in jail, by the lawyers that have gone up with him against him in mob cases and other cases over the years where he's put a lot of people in jail. One of the problems I think with that always happens, and people that see investigations happen that produce an outcome they don't like automatically ascribe political motives to it, when in fact prosecutors want to make cases. Prosecutors don't routinely, we started this forum by criticizing the department for bringing too many cases. Now it's being criticized for not bringing cases, and I think that's one of the things that when you look from the outside, people have outcomes they want to happen. When they don't get those outcomes, they automatically assume it's a political prosecution on one side or the other. Sometimes that happens. The vast majority of the time it doesn't. I know it didn't in Durham's case. To the question about why the Justice Department isn't here, they have to speak for themselves, but I would, having been in their shoes, go out on a limb and say, because three of the leak cases are currently pending, the Justice Department can't sit on a panel like this under department rules and court rules and talk about them. So far from being cowardly, they're just not allowed to.
I'd like to pick up on one thing that you just said, Matthew, and that's the whole question of political motives here. I mean, I'd love to have the two Jameses weigh in on that. What are the political motives here in all of these? Or are there real national security issues, or is this a political case? Most of these political cases. James, on the end, do you want to have anything to say about that?
No, I really don't.
Okay.
Well, obviously, there's politics that go into all these
Right.
cases. These things don't happen by spontaneous combustion. There are people who make decisions, and there's people who make decisions not to prosecute certain people, torture, warrantless eavesdropping, that kind of thing, and people who make decisions to prosecute people. Drake, Mr. Curacao. Yeah, there's politics that goes into this. I think the Obama administration came into a lot of criticism because of the WikiLeaks issue. There was a lot of criticism over how did all these 250,000 pages of documents get out. So I think that factor went into the Obama administration deciding to be tougher on these issues than before.
So is this going to get more intense as this political year rolls out?
Well, yeah, I don't think there's been a lot of, except within the press, there hasn't been a lot of external criticism of the administration for going after this. And I mean, one problem you have here is that you don't have in England to some degree is there's three parties in England. You have Liberal Democrats on the left, you have Labour in the center, and you have the Conservatives on the right. Here you only have two parties, and one is pretty far, almost extreme to the right. And so you have nobody to the left of Obama who is, he doesn't have to appeal to anybody to his left. So he just appeals to his right. He appeals to trying to bring in some of the people who are on the right while taking for granted all these people on the left are just going to, be lemmings and follow him because there's nobody else out there. So I think that type of political issue weighs in on this because he can show that he's tough on leakers, which appeals to a certain political spectrum, while he's doesn't look like he's gone out of his way to do anything against the people who admittedly broke the law by eavesdropping on average U.S. citizens for years and years and years, broke the Foreign Intelligence Surveillance Act. So yeah, I think there's politics that go into all of this, and the politics aren't very pretty.
Any question? Yes, right here. Oh, I'm sorry. Let's start with John and then you. Okay.
So we've talked a bit about when the government decides what it's going to prosecute, what kind of leaks it's going to go after and what kind of leaks it's not going to go after. It's an important debate. But I think there's a separate question related. Under what circumstances is it okay to subpoena a reporter to disclose his sources? And I'm interested in what your take is on that, Matthew, and anyone else who wants to weigh in. But you've said some of these people aren't really whistleblowers. They're people who are disclosing things that shouldn't be disclosed. But then there's a separate question. When's it okay to force reporters to reveal their sources?
Yeah, I actually think that's the hardest question in this entire debate. If you were to look at the spectrum of leak cases on
do they debate that, by the way, in the Justice Department?
Absolutely, absolutely. I would say if you look at the spectrum of leak cases, there are some cases where if someone leaks a piece of classified information, causes national security harm, no whistleblowing motive at all. I think that even a lot of people who criticize the administration might agree that prosecution in some cases is appropriate. On the other end, you have whistleblowers, and then you also have, I think that makes it a tough call, and it makes it a very tough call of when you subpoena reporters. there are strict Department of Justice rules that require the department only to do it when it's exhausted every other measure possible. It's conducted, it's talked to everyone it possibly can, to be very narrow in the way they construct the subpoena, and to really do it as a last resort. Even then, you see them brought very infrequently. Of the 6 leak cases brought by this administration, there's only one in which a reporter has been subpoenaed. Unfortunately, it's Jim. But in the others, they haven't, because it does raise such difficult questions, questions that are to some extent unsettled in law. It raises these difficult questions, and you don't do it lightly. I think I can speak from experience with Jim's case. The decision was made to approve the subpoena because that case, the leak, was seen to be so damaging or potentially damaging. The argument is that you have a lot of circumstantial evidence that Jeffrey Sterling, the man who's indicted, is the source, but there are only 2 people who can testify to that for sure. One can take the Fifth Amendment, the other is a reporter. The argument is that the reporter is the only witness to a very serious crime and should be subpoenaed. Now, the court so far hasn't agreed, so we'll see.
Jim, I'd like to hear your thought. Is there ever a circumstance under which a reporter can or should be subpoenaed?
Well, first of all, I can't discuss what he just discussed.
No, right. I understand. But I mean, broadly, is there ever a case, in your view, could there ever be one?
I really shouldn't discuss this issue right now.
Okay.
Oral arguments in my case are in like 3 weeks.
Fair enough. Okay, Tom. Oh, no, I'm sorry. This gentleman here first.
I'm Mike Springman. I have a question for Mr. Miller. You had said there is a need to prosecute people who disclose classified information. I'll give you an example. At the CIA's consulate in Jeddah, Saudi Arabia, the price of liquor sold to Americans assigned to the consulate was classified confidential, the disclosure of which would cause harm to national security. And from what I could see, the only harm that was ever done by disclosing this was done by a businessman who embarrassed the consulate, and Paul Arvid Tveit, T-V-E-I-T, a clandestine service officer, managed to get him fired and expelled from the country. Now, how is this national security?
I think you'd have a hard time making a case that ought to be prosecuted, and there's a reason why instances like that just aren't prosecuted. They aren't, and it probably never would be. It goes to the overclassification problem we talked about earlier. There are a lot of things that are improperly classified, and you don't see the department bringing cases in those instances. Although obviously we'll disagree potentially on Drake. That's why I say obviously Drake is one that's up for debate, I think.
Yes, sir, in the back. Wait for the microphone, okay? Wait for the microphone.
Just a comment on Saudi Arabia. It's against the law to sell any kind of alcoholic beverage in Saudi Arabia, and the fact that it was subversively and quietly being done is the reason for the classification. And the fact that it's disclosed embarrasses the local government because it's a breach of their laws and so on. So it creates a difficulty, but I'm not arguing against the classification. I wanted to ask the panel, is it not possible that the sheer fact that we're fighting a brand new irregular war against a non-national secret enemy that has raised all kinds of issues, both of intelligence gathering by the part of the government and of reporting of these activities on the part of the press, isn't that one reason why we're in this muddle? And perhaps the Obama administration, unconsciously or consciously, is in a process, as its predecessor was, of trying to sort this stuff out under the law. I would add also that many of the things that have been frankly declared to be illegal by the audience here were things that, rightly or wrongly, the Bush Justice Department found to be legal at the time. And it makes it very difficult for a prosecutor to come along afterwards, and because he basically has to bring the former president of the United States on trial for unconstitutional behavior, since these men were acting under the color and what they thought to be perfectly legal authorities.
Any thoughts? I guess that was more of a statement than a question. So, do we have any other questions?
Well, I think
I'm sorry.
Isn't it possible we're in a
Okay.
a period of adjustment in which we're fighting a conventional war by unconventional war by unconventional means, and we've never had this sort of challenge facing the press or the government before?
Yeah, I think that's the heart of the matter. It's a good question. The fundamental issue is, to my mind, and I've thought a lot about this over the years, is that the point of terrorism is to terrorize a culture and a society. And to the degree that the society allows itself to be changed and transformed by terror, the terrorists are successful. The problem with the way the United States has responded to terrorism is that we have transformed ourselves based on fear. And the culture of secrecy that has surrounded the war on terror has allowed that to happen to a great degree without any public debate. The press's role has been, over time, very haphazardly and in a very ad hoc way, to try to find out what the secret war, what has been going on in the war on terror, and what has been going on in American national security. And that, since it's all secret, we've been conducting this secret war for a decade, we are naturally going to have to find out classified things. And so if you're a war correspondent in the war on terror, you are dealing every day with classified information, or are trying to deal with classified information. It's very different from a war correspondent in World War II. If you're covering the war on terror consider yourself a war correspondent, in the war on terror, everything you're writing about is secret. And so you have to decide, do you want to give up democracy? Do you want to give up a free press? Do you want to give up aggressive investigative reporting in order to fight terrorism? It's a fundamental philosophical issue. And that's what this is really all about.
Okay, yes, Tom, one more. By the way, we have 8 more minutes before the president's going to speak. So.
If we starve liberty for the sake of security, what are we going to have left to defend? So I have a fundamental question for both of the two Jameses. And Matt, you're certainly free to weigh in on this one. I've been told in no uncertain terms by very well-placed reporters, way off the record, that by virtue of my case alone and the others, in terms of the prosecution that have been brought to date, that many of their sources, even reliable sources, are extraordinarily reluctant to go on the record or even off the record. And so, to me, there's something much larger going on here, that it's a direct assault on the First Amendment. First Amendment is fundamental to what this country is all about. How much further can we erode that First Amendment without actually taking away the very basis for what makes us America? Are we willing to actually sacrifice our constitutional form of government for a secret national security state? That's the question. And the press has a fundamental role as the fourth estate in keeping a check on what's really going on in terms of our country.
Just one comment on that is that as you mentioned, that does have a major chilling effect on trying to get sources on other things that happen. I think that's one of the goals of the government, is to create that chilling effect to prevent leaks. The NSA went after you to, not because you're a major danger to the nation, but to use you as an example of what would happen if somebody leaked something from NSA. And the judge, which was very interesting in Tom's case there, a Judge Bennett, who was appointed by the Bush administration, on the final day of the court testimony, after Tom, after the case was basically thrown out and Tom agreed to the misdemeanor, the judge spent virtually his entire time chewing out the NSA and the government for taking the case in the first place, since there was nothing there, and for making his life, I mean, this was his term, making his life hell for 4 years. And I think that's the reason, is to cause a chilling effect. One other factor is on one of my books, The Shadow Factory, and also in a documentary I did for PBS on NSA. I had a couple whistleblowers on there from NSA, and they went full face. They had their names. They were very brave. One of them was a woman who was in what they called she put the earphones on and listened to the conversations. She did all the intercepts, some of the intercepts for NSA. And she was saying, she said right on camera and right for my article, that she was eavesdropping on journalists speaking from overseas to their families at home. And she complained about this. She complained about it internally and right up the chain of command. And they told her she had to keep doing it. And she said, I had to listen to these intimate conversations between journalists and their spouses, and it was like reading somebody's diary. That was all allowed to go on and may still be going on. But again, these aren't the people who are ordering this who are getting prosecuted. It's the people who are blowing the whistle on these issues who are getting prosecuted.
We actually have just 3 minutes. James, you want to say anything more before we break?
Well, he's been trying to
Okay.
answer
All right.
too.
One fine. But
Don't mean to preempt the president, but speaking about WikiLeaks, the government, I work for the Department of State right now, and I'm in the process of being fired for linking on my blog to a WikiLeaks document. The State Department claims that the WikiLeaks documents all retain their classifications, even though they're on the internet and available to the whole world. Would you like to comment on that, Mr. Bamford?
Well, I think that it's absurd to tell government employees that if there's something out there that's on the internet that you can't, that it's classified, but that's the sort of Alice in Wonderland situation that the government seems to be putting itself in by 250,000 documents out there. Some of them could be, some of them are obviously made public, and to have the government consider that they're still classified information is just, like I said, is Alice in Wonderland.
Mr. Miller, the Department of Justice declined to prosecute me based on the State Department's request. Point, the State Department turned it over to their own internal diplomatic security, who found that I had mishandled classified information. Would you consider that a political prosecution?
I doubt very much that decision was made by a political appointee at the State Department. I don't know, but it doesn't sound like the kind of thing that would be handled by a political appointee. The WikiLeaks thing it's completely bizarre. I understand why those documents still remain officially classified. It's so the government doesn't have to officially acknowledge to its allies those activities, but it's one of the odds. I think Alice in Wonderland is the right way to describe it.
Okay, the President is about to speak, and in fact, what he's going to say, I can summarize. He has signed an agreement with President Karzai, and it pledges American support for Afghanistan for 10 years after the withdrawal of all American soldiers at the end of 2014. And I suspect he's going to say that as well to the American people. So, so thank you very much. It's been a great pleasure to be here from the OPC to the NPC. And you can find this as well on opcofamerica.org. Thank you, John.
Very nice.